The envelope is pushed through your letterbox on a Thursday morning. Section 21. Notice. Your landlord's name is printed at the top. The date says you have 2 months to leave. You put it on the kitchen counter and tell yourself you'll deal with it later. The action is simple. You didn't reply to the Section 21 notice. For weeks, nothing looks different. You keep paying rent. The tenancy feels unchanged. You assume there will be a conversation before anything serious happens. The 2 months expire. Another letter arrives. This one says the landlord has applied to the court for possession. There's a claim number, a response pack, a deadline to file a defense in writing. The process has already moved on without you. You read it twice. You didn't move out. You didn't formally object either. You thought silence kept things open. The paperwork treats the silence as the end of the notice period. You fill in the defense form quickly. There are boxes to tick, a small space to explain your position. You write that you need more time, that you didn't understand how quickly it would progress. You send it back before the deadline. Weeks later, another document arrives. It's a possession order. It sets a date by which you must leave the property. The pages list the original notice, the expiry date, and confirm that the landlord followed the correct sequence. Your reasons aren't discussed, your intention isn't questioned. The focus stays on dates. If you want to delay eviction, there's another application. A separate form, a fee. A short statement explaining why leaving by the stated date would cause exceptional hardship. It must be submitted within days. If granted, it may extend the deadline briefly, not cancel it. You are no longer disputing the notice itself. You are asking for time after the order has been made, and each document refers back to the first one. The Section 21 notice. The 2-month period. The absence of a formal challenge before it expired. There's no accusation of wrongdoing, no claim of rent arrears, no breach alleged. The sequence is enough. Notice served, notice expired, claim issued, order made. If the defense form hadn't been returned, the order could have been granted without a hearing. If the hardship application isn't filed correctly, enforcement can be requested. Each stage runs on its own timetable. You thought not replying meant you were still deciding. The record shows that nothing interrupted the notice while it was active. The process didn't wait for a conversation. It moved when the date passed. The hardest part is recognizing who this catches. Not tenants ignoring everything. Tenants hoping for flexibility. Tenants who believe that if they haven't agreed, nothing can move forward. The reversal is this. The letter you left unanswered didn't just sit on the counter. It counted down. And the part of you that waited for a proper discussion is the same part. The paperwork reads as having let the eviction process begin without a word.